and welcome to this edition of Trader Talk TV. Today we've got Yves in the office from the IAB. Yves, thanks for coming.
Thanks for having me.
And today we're going to talk about GDPR and its effect on the ecosystem. Now, you probably don't know what GDPR is, or maybe you do. At this stage you should. Yves here to talk about that particular subject and what the ecosystem might look like in 12 months' time. Yves, obviously your time's been taken off for the last couple of months talking about this. Many panels, many discussions.
Yeah.
Can you sort of give us an overview of this regulation that's coming in? Because we want to talk about it on a high level, and then we want to talk about some of the stuff that you guys are doing with your members, and obviously the IAB Europe as well. And maybe talk a little bit further along the line about what effect this might have on the ecosystem as a whole.
Absolutely, yeah, cool. Well, the GDPR ultimately can be boiled down from our point of view into 5 things that you need to know about, right? The first one is it's all about personal data. GDPR kicks in the moment you process personal data. Importantly, personal data is much broader than what we normally know as PII. Everyone in the industry will have heard about PII, personally identifiable information. In fact, PII has no validity whatsoever in Europe. That is an American concept that was sort of taken on perhaps by American companies setting up shop in the UK and elsewhere in Europe. They would use that in the context of even data protection law in Europe. What European regulators are interested in is personal data.
Right.
So personal data is a very broad concept, meaning that effectively any piece of information that we can use as an industry will be captured by it. And for that reason, most companies, if not every single company in the digital advertising ecosystem, has to comply with the GDPR. The second one is the GDPR has global implications. And I'm saying that because the GDPR can apply to you even if you're based outside the EU. So in one or two ways, or actually depending if you do both, and in those 2 ways. The first one is if you offer goods or services to individuals based in the EU, even if you're based outside the EU, you have to comply with the GDPR. So take Walmart, for example, as a US retailer. If they ship their products to the UK or elsewhere in Europe, they will have to comply with the GDPR.
Yeah.
Perhaps not that relevant to us as an industry. More importantly, though, if you monitor individuals' behavior in the EU, i.e. if you sort of track their preferences online, regardless of where you're based in the world, you will still have to comply with the GDPR if that data comes out of the European Union. So for that reason, lots of companies that perhaps previously haven't necessarily been subject to EU data protection law will have to comply with the GDPR. The third one is to be able to actually process personal data as a result of the GDPR, you will have to justify it. The GDPR effectively says that you're not allowed to process any personal data unless you can justify it. There's 6 ways for you to justify it. Policy people, legal people normally refer to them as legal bases. Out of the 6 legal bases, 2 are important for us as an industry, and that's consent and legitimate interest.
So let's just talk about both those because they're quite important in terms of how ad tech companies, martech companies justify their existence.
Yes.
And how they can actually still operate in a post GDPR world. So let's talk about the consent thing first. There's a lot of discussion around what is required for you to target a particular user. So is it explicit consent? Is it consent per site? And this is the part that's kind of like a little bit grey at the minute.
Consent is a very important piece, and this is where we actually have to look beyond the GDPR. And the reason for why I'm saying this is that consent also becomes very relevant in the context of what in the industry is often known as the cookie law.
Right.
Although that's perhaps the biggest misnomer we've ever come up with, because the cookie law actually covers a lot of other different things. In the UK, the cookie law is known as PECA, which stands for Privacy and Electronic Communications Regulations. This is a piece of law that will still apply even when the GDPR kicks in. It is actually in the process of being updated at European level, but that won't be done in time for when the GDPR kicks in. So we have PECA on one side and GDPR rather on the other side. So if you drew a Venn diagram, you would have this and you have this overlap here, and this is where consent for cookies comes in and similar technologies. Because PECA kicks in the moment you want to access information on a user's device or store information on a user's device. And it says that for those purposes, you have to get consent and you have no other option available to you. And consent from PECA comes from the GDPR's predecessor. But from the 25th of May 2018, when the GDPR kicks in, when you look at PECA, you will see that the consent derives from the GDPR. So we need to know what consent under the GDPR looks like for the purpose of collecting information on a user's device or storing information on a user's device. And consent under the GDPR has been strengthened significantly to what we're currently used to. Right now, you're going to publish a site, you see a banner that says something along the lines of by continuing to use it. Exactly. That will have to change because that's very much based on the understanding of implied consent, sort of an opt-out regime. Where consent applies and where it's required under the GDPR as a result of this Venn diagram that we just drew, it's less of a question of whether it's going to be an opt-out or an opt-in. It's going to be how an extreme of an opt-in is it going to be, I think, in many ways. And the reason for why I'm saying that is that consent under the GDPR now requires some sort of affirmative action from the individual. Something positive needs to happen from the individual for the consent to be valid, which means when you look at a publisher's site, it is very unlikely that they'll be able to effectively collect information or drop cookies on a user's device before they receive a signal from the user whether they're okay with it. That's quite a significant change to what we have currently. Two more areas where consent becomes very important. It can no longer be bundled in T's and C's, which means that you have to separate it out if it's not required for the service. So, for example, you sign up to a new mobile operator. Mm-hmm. Usually right now you sign up, you'll probably sign, when you sign the contract, in the contract itself, it'll say something along the lines of, your data might be used for marketing communications or whatever. Under the GDPR, that will have to change. The data they want to collect, which isn't necessary for the contract itself, for performing the contract, you will have to get separate consent for that. So T's and C's is another big area. The final piece that needs to be mentioned in the context of consent is what happens if I have to rely on consent and I can't get it as a publisher, for example. What are my options? And this is where it gets a bit tricky because this is an area in the GDPR where different interpretations exist. Our interpretation from the IAB point of view is that publishers could effectively say, sorry, you can't access our site, for example. Or at the very least, you can access our site, but you can only sort of access or your access has slightly lower quality, restricted access.
So like a 1980s version with like crap text and no data.
Potentially. Obviously, that all depends on the publisher, right?
Yeah.
And what they want to do. There are regulators and certain policymakers in Europe that feel very differently about it. That they think publishers would still have to give access to people even if they don't
that's
consent.
just insane. It's like me going into a shop and taking all the sweets and all the chocolates and saying, I'm not paying you because I have a right to this. It's like, steal my content but not pay for it. That will not get through the European Union. I'm pretty sure of that.
We would certainly hope so in many ways. But the regulators and the policymakers in Europe that argue that case say that effectively privacy is a fundamental right under European law.
Well, so is actually making money.
That's where I agree.
If you make content, you can't like expect for free.
Yes.
We don't live in a communist state. Last time I checked, anyway. So the consent thing's interesting. There's a couple of things I'm just going to sort of. There's a lot of Portuguese publishers working at it with a single sign-on. So single sign-on means you can just basically log into a site across that. Does that mean that when you sign on, those same publishers are going to have to ask you again if you're happy to be targeted in a sort of like using advertising?
Not as long as a consent request is specific. So for consent to be valid, it has to be specific. The individual effectively has to know where their data might end up.
Right.
Whether that has to be done the very first time you talk to the individual, or whether the individual is given sort of opportunities to find out more after a click or two, is still to be decided a little bit. We are certainly very positive, and we feel very positively about this idea of a layered approach. So you might give them an all or nothing choice to start with, and then individuals can find out more further down the line. But the individual effectively has to know what happens to their data. So if it's across a publisher alliance, for example, they should know who's part of that alliance.
All right. So the other thing as well, you just talk about the governments in Europe looking to allow people access even if they have. That actually negates paywalls as well. I mean, if you extend their idiotic logic, and that's what it is, because most people in Europe are like that, they are effectively saying if you have a paywall, then you should not have to pay that, and you should get that content for free, because that's exactly saying the same thing. Because how does publishers pay for their content? They use advertising. And where does advertising mostly come from? Targeted advertising. So it doesn't make any sense at all.
No, I agree. We definitely agree with you, and I think we don't necessarily know what regulators or how they feel fully about this until they publish a final piece of guidance on consent. So far, they've only published a draft where I think you could read that draft in a way that would suggest that even paywalls wouldn't be an option.
Yeah.
But we don't know yet, and that draft, the final version, will probably be published towards the end of this month. Maybe early March.
So that's consent.
That's consent.
And this is the most
lots of people talking
piece
about
around.
this. Yes.
Our favourite retargeters in the world are talking about this as a means to continue their business. So let's talk about legitimate interest and what exactly that means and how you can derive consent from this.
I think there's a lot of interest around legitimate interest.
Fair enough.
As a result of consent being so difficult, as we've just described, consent being a really difficult challenge. Legitimate interest, effectively the idea behind it is, if you think as a business it's in your legitimate interest to process someone's personal data, you can do that. Unless the interests of the individual, which would be sort of their right to data protection, their right to privacy, override your interests. And for you to find out whether the interests of the individual override your own business interests, you have to conduct something that is known as a balancing test. You effectively have to do something that looks a little bit like a privacy impact assessment before you start anything, to understand where the pendulum swings, whether it's in your favor or towards the individual. So how you do that is normally you ask yourself questions. For example, would the individual reasonably expect for me to process the data in the way I want to process it? And perhaps a little, depending on the relationship you have with that individual, the answer might be yes or no. If it's no, it doesn't necessarily automatically mean that you can't rely on legitimate interest. You may have to do more things so that the pendulum swings in your favor.
You are relying on an awful lot of assumptions. You're assuming
it's very subjective. It's super subjective.
I'm assuming you're okay with me to take your data and then retarget you on another site.
Well, you have to record it. You have to actually justify it. So if a regulator, and regulators and individuals can challenge you at any point if you think you have legitimate interest. They could effectively go in and ask, show me, and you actually have to show individuals that you have a legitimate interest if you rely on it. And so you have to tell them exactly why you think you have a legitimate interest. You can't just assume that you have a legitimate interest.
So how is this going to pan out then? This is interesting, legitimate interest.
Yeah.
But it's a case of like, how does this get defined? Is this a case that it needs to be tested in a court of law for it to be say yeah, or is again like it depends on the judge who's overall the jury overriding this sort of looking after this particular case. So how does that actually get benchmarked?
Yeah, lots of people in the industry have been asking for guidance from regulators about this. Like, give us an idea of what legitimate interest could be. And the GDPR talks a little bit about what can be a legitimate interest. So it says fraudulent activity. If you want to investigate fraud, for example, it's very likely that would be in your legitimate interest, because obviously you can't ask for someone's consent to do that. It also talks about the fact that direct marketing could be a legitimate interest. Not necessarily will be, it could be. And obviously there's a question around whether the types of advertising that you see in digital advertising or sort of, in programmatic advertising in particular would be a form of direct marketing. But again, this is where we come back to this idea of where PECA and the cookie law kicks in. So again, there's a lot of interest around it. It's very subjective. It can be challenged at any point, but you have certain benefits because consent is actually quite difficult to achieve. Okay,
so what about 4 and 5?
4 and 5, very quickly. 4 is lots of individual rights. The GDPR gives individuals a long list of rights. They're also known as, one of the rights would be, for example, a subject access request, where you can go to a company and ask. Yeah. Exactly, you can ask for a copy of your data effectively.
So basically, you can rock up the day after the GDPR and ask a publication or a ad tech company for details about what the information they're holding.
Yes, and in many ways you can already do that, because existing data protection law already provides that right to individuals. The GDPR actually sort of enhances it a little bit. But you could effectively already go to organizations and ask for a copy of your personal data. There are lots of other rights. We probably don't have time to go through all of them, but it's very important to understand that companies will have to have processes in place to be able to comply with those rights.
Okay.
The 5th one is a very famous one. Huge fines. We know that right now, in the UK, the ICO, the Information Commissioner's Office, is the regulator that we have when it comes to data protection and privacy. They can levy fines of up to £500,000. A lot of money, not necessarily existential for some. Obviously, under the GDPR, up to 4% of global revenue, annual revenue. So we could all of a sudden potentially see fines that go into the millions, tens of millions, hundreds of millions. This is not to say that regulators will go out and fine people left, right, and centre. They actually have to go through a long list of criteria to understand how, whether a fine is appropriate in the first place and how big the fine should be. Also, fines can always be appealed and challenged by the companies or organisations that are being fined.
Okay, so 5 good points to go there, but let's talk about what you guys are doing with your own members.
Yes.
And obviously IAB Europe, which is sort of spearheading a initiative around consent or general consent for most publishers.
Yeah.
So let's talk about that first.
So effectively, what we've come together under the umbrella of IAB Europe, which brings together all national IABs in Europe and some companies as well, to look at this challenge of consent. We understand that consent is obviously a huge challenge. Again, coming back to the point about the GDPR and the existing cookie law, making it an even greater challenge than it otherwise would already be. And what we're trying to do is effectively help companies address that challenge. The framework that you've just referred to is effectively a transparency and consent framework. What it's trying to do is to provide publishers in particular in the first instance a way to effectively capture consent, store that consent and transmit that consent throughout the chain. And that's important because ultimately, as a result of the GDPR, you want to be in a position as a company to be able to record all the things that you do to be compliant. And the GDPR introduces another thing that we didn't just talk about, which is this idea of joint liability. Regardless of where you are in the chain, you could be liable. For that reason, you need a record as a company to understand, in the context of consent, where did I get this consent? What did the language look like that the individual consented to? And that's what we're trying to help with.
So the consent, the catch-all consent that the IAB, is it a sort of a pop-up and then you basically consent to it? Because the problem I have here is that because there is no user, there's no you don't connect with the user at all, right?
Yeah.
It doesn't log in. There's no sort of user-facing connection. That effectively we're all just kind of effectively based on that cookie, right?
Yeah.
So it's the cookie that's like, and it's the user that sees that ad and gets annoyed and go. So talk about being able to kind of track that all back to the initial source. It just seems very messy, and seems to be sort of a bit disjointed.
So what the framework doesn't necessarily talk about is exactly what the user experience is going to look like. What the framework effectively is, think of it as a language. It's a way for us to store consent and transmit consent and allow publishers to effectively communicate with the individual all the different pieces of information they need to communicate to make the consent valid. We very much will leave it to publishers because that's also the feedback that we've received from publishers. They need flexibility in the way they talk to their audiences. But I think it is very likely that we'll see more pop-ups, interstitials, whatever you want to call them, that will include far more information than the ones that we're currently used to. For example, the banners that we currently see, that may very well name all the different third parties that the publisher wants to get consent for, and the different purposes for which they want to get consent. Right. Which is again where the framework helps, because it effectively gives publishers an API they can plug into, so they can actually show that to individuals. But yes, I think we will see far more information. We will see far more disruption in the experience that users have when they go online.
Okay, so I've had some people talk to me about this and they feel confident about GDPR. I don't know why, but they feel confident about it. And they are more worried about the brands. They're more worried about what advertisers might do. Because the last thing an advertiser wants to do is be implicated in some like data privacy court case and brand mess. So how do you think this will affect the ecosystem going forward? I mean, like, will it? Do you think it's going to clean up the supply chain? Do you think that the pendulum effectively swings back towards the big premium publishers who actually have the relationship with users as opposed to the middlemen players?
I think there is definitely a benefit in having a direct relationship with the user. So having a user interface will certainly help, I think, particularly with the consent challenge. I also think that this issue of transparency that we also see pop up obviously in lots of other areas when it comes to ad tech, be it brand safety, viewability, ad fraud, all these places, will again be supercharged by the GDPR as a result of publishers as well as advertisers, anyone in the ecosystem effectively having to know much more about the people they share data with and the people they receive data from. Again, as a result of this idea of joint liability, because if I don't know, I may expose myself to a great level of risk. So I think it will deal with a lot of the perhaps some of the challenges that we face in the ecosystem around where does data end up, and does it end up in the right place, and who does it end up with. But again, I would agree with you. I think for me it's still difficult to really think of the GDPR as an opportunity when I see all the things that companies have to go through to be able to comply with it.
Yeah. And what about then this is obviously the first step, and then e-privacy could potentially come up later in the year.
Yeah.
How do you think that all that will join together at the end of the year?
So again, it's very important to understand or to come back to this diagram I drew up, earlier, which was we have the GDPR from the 25th of May 2018. We have the existing cookie law, again misnomer, but we have the existing cookie law. What is currently being done at European level is updating the existing cookie law, which is known as the e-privacy or the future e-privacy regulation. We don't really know yet when that's going to land. It was meant to come into play and meant to come into force at the same time as the GDPR in May. It's a very political process, which meant that it's now been delayed effectively, and we don't have a firm sort of timeline in terms of when it's going to come in. Our best guess is it will probably be a case of the EU agreeing that the entire piece earliest at the end of this year, and then potentially could come in fully into effect at some point in 2019. But it does have the potential to go even further than the GDPR.
What sense?
In the sense that the GDPR is a very, very general piece of legislation. It uses that word in the name. So it applies to any organisation that processes personal data. It's obviously much broader than just digital advertising, right? The e-privacy, which sort of it complements the GDPR, or the language that the European Union likes to use, it particularizes the GDPR. And what that means is effectively the EU thinks that in the area of sort of telcos, in the area of electronic communications, a more sectoral approach is needed that sort of sits on top of the GDPR and very much uses the GDPR as a basis, but may go a bit further. So one of the proposals that was put on the table as a result was to effectively turn browsers into gatekeepers for consent. So that there would be at the very top level, individuals would indicate whether they're happy or not at the browser level, and then publishers and third parties relying on that consent would have to react accordingly. We actually think it may not necessarily be the idea of a browser as a gatekeeper may not actually comply with the GDPR itself, and I think people are moving away from it. Because again, consent needs to be very specific. And how can you tell an individual at a browser level that whether consent that they give or refuse to give, to whom it applies, when you effectively try to do that for the entire web, right? You can't, as a browser, you can't tell exactly the individual which sites they're going to access and what third parties behind that will want to have access or want to get consent. So the specificity point that comes as a result of the GDPR will be very, very interesting to see how that's going to be dealt with in this future, in the future cookie law.
And that'll probably be the end of the year, will you?
I would think so. Yeah, I think it's a very political process. Our hope is actually that some sort of not necessarily that, like some sort of common sense prevails, because I think there's huge value in understanding how the GDPR will work out in practice, and maybe park the future of e-privacy for a while just to see how effective the GDPR is, and then to understand where are the gaps and how do we plug those gaps.
Okay. Yves, thanks for that overview.
No worries.
I'm sure you're going to be busy for the next couple of months.
I'm sure
we'll have you again if the privacy things kind of surfaces in the next couple of months. We'll have you in again to talk about
Brilliant.
that.
Thanks
for
for
your time. And that was Trade to Talk TV, and we'll see you next time.